Ghislaine Maxwell's defense lawyer, Bobbi Sternheim, just submitted a letter to the court. It's a motion for a new trial, saying that the last trial we just had was problematic. Juror number 50, the guy who had a prior history of abuse that he didn't disclose, requires a whole do-over on this thing. We can't really see what's inside the motion, but we can see the cover. Here's what it says. It says, Judge Nathan, today, counsel for Ghislaine Maxwell filed her motion for a new trial, hereinafter known as the motion, and accompanying exhibits under seal. So it's not just a motion, there's exhibits, and they've got some documents that they want to rely on. It says, for the reasons set forth in the motion, we request that all submissions pertaining to juror number 50 remain under seal until the court rules on the motion. Signed off on by lead attorney Bobbi Sternheim. We spent a lot of time talking about her. Filed over to Judge Allison Nathan, January 19th. 2 pages, really just one. And so not much here that we can glean from this document. We know that there are and have been a lot of problems with Juror 50. We know there were other entries on the court docket about that juror. Here's what they looked like. So we had entry 576. This was an order requiring the parties to indicate whether Juror 50's motion to intervene and completed questionnaire should be redacted. And so now we have juror number 50. We're going to refresh our memory on this guy next, the clip from him where he is sort of realizing the consequences of this non-disclosure of his. But you can see that he has hired a lawyer and they've actually intervened in this case. And so now they're requesting copies of documents. They want the questionnaire, they want copies of the voir dire. And so they want a lot of materials, and they're having conversations about whether we give it to them and whether they should get the originals or whether they should be redacted. And so we're going to take a look at some of these issues. We have also entry 577, joint letter regarding scheduling for sentencing and resolution. Remember, we have the severed perjury counts. Ghislaine Maxwell was convicted 5 of 6 counts, but there were the 2 other perjury charges that came from that deposition. And so they were going to reschedule those for a separate trial. But then we had other issues, the judgment for acquittal, the motion for a judgment for acquittal, before we even had the juror number 50 issue. And so we, who knows if we're even going to get to the perjury counts or when those will be, but they want briefs. They want a schedule, sentencing, and all of that stuff. They want letters from, we have another letter here dated from the prosecutors about speedy trial. We'll take a look at that document as well. All right. Juror number 50. Remember this guy? He is being interviewed in this clip by the Daily Mail, and their volume in this clip is quite low. And the woman who is the interviewer also has a British accent, so it's kind of hard to hear exactly what she's saying. But she's saying, you decided to share your story. Why did you do that? Here's what he says.
So it took to day 3 for you to really reach that level of understanding with each other and then make true progress with the deliberations? Would that be a fair assessment?
Yes.
So you decided to share your story. Presumably that's something that you'd tick yes to in the questionnaire. It was something that people were aware of when you were selected as a juror.
No, they don't ask your sexual abuse history. They didn't ask it in the questionnaire.
I thought in the questionnaire there was a question that asked if you were a victim or if you were a friend or a relative of a victim.
Yeah.
Pretty sure it was number 48.
Number 48, she says. Looking at it right now.
I don't remember.
Somebody sent me the questionnaire today and there was a question.
Interesting.
I mean, I guess, when did you fill in that questionnaire?
I definitely, on the first day of jury selection, I would have definitely marked yes, but I honestly don't remember that question.
You're not in the stand right now, too.
No. I mean, I know my face is red because I can feel the blood, but I honestly, that's why I answered it that way. I don't remember it being there, but I did answer, I definitely remember a family or relative or something, but being sexually abused. I was honest on all my questions.
Oh, yeah,
I'm sure he was. It was just an oversight. But now that that oversight is in play, does Ghislaine Maxwell get a new trial? We're going to have to figure that out. But we can see we've got an order here from the judge. That was juror number 50 that we just listened to. And so the court is writing here. Entered on January 14th, 2 pages. Says the court required the parties to indicate whether juror 50, who we just heard from, whether his motion to intervene and to be provided a copy of the juror's completed questionnaire and voir dire should be redacted. So the juror's questionnaire, that's going to be what they filled out, right? That's exactly what he filled out. And voir dire, that's jury selection. right? That's when you're asking the entire panel of jurors different questions. So his question, the voir dire, all of these forms and these different things that happened in the trial, his lawyer wants copies of those. And so the judge says, we need to have a conversation about this. Should they be redacted? In response, the parties have submitted letters to the court indicating their differing views on whether the juror's motion should be docketed at all. Court kind of jumped the gun a little bit. Court's saying, well, should we give him copies of this? And the defense or the prosecution, somebody's saying we shouldn't even listen to him in the first place, or it shouldn't even be docketed on this case. Upon further reflection, the judge writes, court concludes that it must first address the threshold issue of whether an inquiry is permitted and or required before considering Juror 50's requests. Okay, whether the court needs to go and figure out what happened here before they even cooperate with Juror 50. Threshold issue. Got to figure one thing out before the other. Accordingly, Judge Nathan writes, the court will not consider or act on Juror 50's request to intervene or to be provided a copy of the questionnaire or voir dire until the court receives the parties' briefing on the appropriateness of an inquiry and the nature of such an inquiry. I need to know, says Judge Nathan, how I should go and investigate this problem. You say there's a jury problem. What should I do about it? What's the nature of my investigation and how appropriate is the investigation? Let me know. Then once I know on that issue, I can decide whether to actually conduct an inquiry and then as a consequence of the inquiry, decide what to do with Juror 50. The court will maintain Juror 50's motion temporarily under seal until the court considers the parties' arguments and determines the appropriate next steps. So we've got a couple different things that have to happen before we can even give Juror 50 the documents. Consistent with this and to lessen the burden on the parties in the court adjusts the briefing schedule as follows. So reschedule your calendars, folks. Rather than separately addressing Juror 50's motion on January 20th, they may address the issues raised by their motion on schedule previously set by the court. Finally, the court says, Judge Nathan writes, in an abundance of caution, the court assumes that while these issues are briefed and resolved, the parties are in full compliance with the Second Circuit rules. That rule says that notice and the court's permission is required before you talk to jurors. So if you're investigating this defense or prosecution, you can't just get out there and start contacting all these jurors. You got to make sure you've got court permission and notice. They cite the case. Judge says any failure to abide by that precedent must be reported to the court immediately. So ordered. So if the defense or the prosecution, if they're having conversations with jurors or anybody from their teams are independent investigators, if everybody's going out there and having a free-for-all, just calling all these people, were you abused? Were you abused? Were you abused? Then that is a problem. You got to notify the court, get permission, because the court's going to micromanage this thing. There's an investigation, an inquiry that's going to have to take place, and the judge wants to make sure no more of this trial is tainted. We have another order, as we talked about previously. And the other order is about the sentencing and the resolution of the perjury counts. Okay, so remember, in addition to all this Juror 50 stuff, we also have Ghislaine Maxwell that has a new trial, a second trial for the perjury counts, as well as being sentenced on what she was already convicted for. She's been convicted on 5 of 6 counts. She's got to be sentenced for those charges. But the defense is saying she's going to get a new trial, and we have to brief a motion for a judgment of acquittal because of all the problems that happened in the original trial in the first place. So we've got a lot of problems here that they're going to be latching onto. So the court says we are going to just schedule this for sentencing in June, which is obviously a long time from today. This was filed on the 14th, so that's over 6 months out. 6 months and 2 weeks. The court will delay ordering the preparation of the pre-sentence investigation until April. And anytime somebody goes and gets sentenced, they have to go and be interviewed and have conversations about what an appropriate sentence might be from the probation department, from the sort of the independent body that is not the defense, that's not the prosecution, that's also going to be recommending what the sentence would be. But She might not even be sentenced on this if she gets a new trial. The court previously set the schedule for briefing on the new trial as well as the other post-verdict motions, and so that schedule remains in place. The court adopts the parties' proposal that the scheduling of any proceedings be deferred until the post-verdict motions are resolved. So anything for the perjury counts, that's just on hold indefinitely. Not even worried about that. By January, the government shall indicate in a joint letter whether they're seeking exclusion under the Speedy Trial Act. And as we're going to see, they are. So speedy trial, you hear this all the time, right? I have a right to a speedy trial. You can't just do like the Count of Monte Cristo and throw Edmond Dantes into the prison indefinitely and hold him without any due process or trial. No, you need to have a trial. And so Ghislaine has a right to a speedy trial under U.S. Code. But because of all these shenanigans going on, the prosecution here, Maureen Comey and co., they're writing to Judge Allison Nathan. They say, Judge, the government submits this letter to respectfully request that the court exclude time under the Speedy Trial Act for counts 7 and 8. We want you to exclude the time. So basically, the time from now until April 1st is not going to count against the government. The government has a duty to bring a trial with speed, with haste. And any time that is counted against that effort is going to be excluded. In other words, it's not going to be held against the government. This time is not going to count on their clock. All of the time from April through April from today's date. The exclusion time, the government says, will further the interest of justice by permitting the parties to research and brief post-trial motions. The government has conferred with the defense and they agree. They're waiving it, so it's not a big deal. And it's going to get pushed out. So the judge ruled then on January 18th, says, with respect to counts 7 and 8, the court excludes the time, so it's not going to count against the government. The court finds that the ends of justice is served by granting this exclusion from the speedy trial computations. It says it outweighs the interest of justice and the defendant because time is necessary for the parties to research and brief post-trial motions. So ordered, Judge Nathan 119. So Judge Allison Nathan is giving the parties plenty of time. She's recognizing these are serious issues. Juror number 50. We're going to push all of the perjury stuff out for a long time and even waive speedy trial rights. So if we summarize all of this, does Ghislaine Maxwell have some reversal opportunities? Of course, she got convicted 5 of 6 counts, but is there anything she can do to change course? Well, yeah, we just talked about it. Juror number 50 came out, introduced some new problems. Juror number 50, of course, is the basis for the motion for a new trial. We have 3 other jurors who may be in similar boats. We talked about this previously on the channel. We have a live show that we do, and so if you're not subscribed, stick around for that. But we have 3 other jurors that they're hinting at may also have some problems. We have the judgment of acquittal, which was being floated before we even learned about juror number 50. This is the idea that there were problems that occurred during Ghislaine Maxwell's trial in the first place, and that the judge made some erroneous objections or admitted some evidence or whatever. And so the defense was already working on the judgment of acquittal, and they were also considering other technical arguments like the non-prosecution agreement, and I'm sure we're going to see appeals up to the circuit court. And so Ghislaine Maxwell still has a long road ahead. She might even have a new trial. It just depends. We're going to see what Judge Allison Nathan says about it. We're going to see if more information comes out about these other 3 jurors. We're going to see what other insane events happen in the Ghislaine Maxwell trial, because we might be doing this all over again. What do you think about the Ghislaine Maxwell saga? What do you think about these reversal opportunities? You thinking she walks or not? Let me know what you think down in the comments below. Hit that subscribe button. As I mentioned, we have a live show every day of the week. We'd love it if you stuck around because it's better when we do it together. I look forward to seeing you on the next one.